Okay, I cannot see counsel for the appellant. Counsel, could you just say something so that your face will come up?
Yes, good morning, Your Honor.
Okay. Thank you very much. This is the matter of State versus POMPEI. Each side will have 30 minutes to argue. The appellant may reserve any portion of that argument for rebuttal. Justice Doria will be our timekeeper. And the way we do this is if any of the justices have a question, they will raise their hand. I am now having an echo. Is there anyone else having that?
Mr. Seguro, I'm going to mute your mic and see if that's it.
Okay.
Is that it?
That's it. Sounds like it fixed it, whatever that was.
And Chief, can folks see me? Am I on their screen? So if I put up the, okay, very good. Thanks.
Okay. So Justice Doria will be our timekeeper. He will let you know when there's 5 minutes left in your argument. When you see a justice raise their hand, either in video or by the virtual hand, please stop your argument at that point. I will acknowledge the justice and they will ask the question. Are the parties ready to proceed?
Ready, Your Honor.
Whenever you're ready, counsel. Please identify yourself for the record and let me know how much time you wish to reserve for rebuttal.
Thank you. Attorney Gerald Lentini, arguing for the appellant. I'm joined at counsel table by my co-counsel, Attorney Robert Fontaine. And with the court's permission, since we are in the same room and he has just returned from the GA, I would like to remain masked for safety. I'm reserving 7 minutes from my initial argument for rebuttal.
Yes, counsel, that's fine. We can hear you clearly, which is great. Sometimes the mask are problems, but it's not this time. Whenever you're ready to proceed.
Thank you, and Mr. Chief Justice, and may it please the court. The issue before the court today is whether an armed, uniformed officer driving a marked police cruiser who parks it in such a way as to block a person's vehicle from being able to move has affected a seizure. For 3 reasons, we believe, yes, Your Honor.
I try not to start questions this early, but in this case, I think I do have a question that I want to ask right now. The record seems to indicate that your client didn't know that he was blocked in. Does that make a difference?
I don't believe it does, Your Honor. The standard here is the reasonable person standard. The U.S. Supreme Court in the United States v. Mendenhall explained that was whether, in view of all of the circumstances surrounding an incident, a reasonable person would have believed that he was not free to leave. I don't believe that implies that the reasonable person who's used here, who is a hypothetical person, is only confined to the perceptions that the defendant had. I know that this court does not follow California v. Hadari D in terms of how this standard works, but the Supreme Court's explanation in there is that this test is an objective one. It's not what the citizen perceived, whether he perceived that he was ordered to restrict his movement, but whether the officer's words and actions would have conveyed that to a reasonable person.
Is that the same argument that was made in trial court?
No, Your Honor. In trial court, we argued in the alternative after making the initial argument that a seizure had taken place, that once the defendant was awakened by the officer, he would have been able to perceive a uniformed, armed officer standing outside his door with a marked police cruiser blocking him in. This still occurred prior to reasonable and articulable suspicion being developed, according to the officer's testimony and the court's finding.
I do have another question. I see the other justices have questions, so I'm going to ask one more question and I want to pass it on. The record indicates that the officer, when he arrived at the scene, he was there basically to do a safety check. Does that make a difference?
I don't believe so, Your Honor. The officer's subjective intent behind his actions is not as important as the objective question of what a reasonable person would have perceived.
So if a person, hang on. So if a person's in distress or a person is ill, a person needs help, and an officer goes up to help them or to try to find out whether they need help, they are seized?
Not necessarily, Your Honor. It depends on the.
Why is this different?
Because in this instance, the officer acted in such a way as to remove the defendant's ability to leave the scene by blocking him in. That was the key point that affected a seizure. Had the officer merely parked in another space, for example, and approached the vehicle, we would be analyzing this as a consensual encounter.
So if an officer drives up, same facts here, except for it turns out that there was a medical emergency. You're saying that if the person in the car, the officer drives up, they are seized.
That's if the officer drives up and then blocks the defendant in from the position where he would not.
Regardless of his intent or anything else like that. That's just the mere fact that the car is behind the other car.
Behind the other car with nothing in front of it would be a different story. But in this instance, because it was behind the car and the car was up against a building, there was no way for that vehicle to leave. That affected a seizure. Additionally, the officer did not have a basis for knowing that there was a medical emergency at that point. So we would still be hypothetical.
Do you have any case law on point for that argument?
For whether or not the location of the vehicle is relevant, Your Honor?
No, just the person is seized because the officer drives up, the car can't drive forward, and that alone, regardless of what the officer's intent was, regardless of any other factors.
Yes, Your Honor. So we have case law, both federal and state level, that indicates that the blocking of a car demonstrates a greater show of authority than a consensual encounter, and that a reasonable person would not feel free to leave if their vehicle has been impeded by
that seems to strip away all the other facts.
Well, I do believe that that is the most salient fact here, Your Honor. The vehicle was, by the officer's decision to park behind it in such a way that it could not leave, effectively seized.
Okay, I'm going to pass it on to, and I don't know the order. I believe it's Justice Keller, Justice Kahn, Justice Doria. Does that sound right?
Good morning, Attorney Lentini. You're talking about the reasonable person standard in your response to Justice Robinson, Chief Justice Robinson's question. I thought that standard is a reasonable person in the circumstances that the defendant is in at the time. So aren't we supposed to be looking at a reasonable person who might have been asleep at the time?
So the reasonable person would be in the defendant's circumstances, but not necessarily confined to the defendant's perception of events. The reasonable person is aware of, for example, the number.
Well, no, I know, but it's the perception that's formed under the circumstances that the defendant is in that would be formed by a reasonable person in the same circumstances. In this case, the reasonable person we would have to consider to be asleep when the cop blocks the car from the back.
So as we mentioned in our argument in front of the trial court, even if we were to accept that restriction on the reasonable person analysis, at the moment that the defendant awoke, the defendant was still not subject to a reasonable and articulable suspicion that a crime had been committed. The officer testified he did not form that until after the defendant had rolled down his window, in which case we can still find that a seizure took place in this instance before a—
Couldn't he have opened the door and walked away? Why couldn't he open the door and walk away, even if the car was blocked from behind?
Well, that would require us to assume that the abandonment of the vehicle is reasonable in this case, and that the vehicle itself wouldn't have been seized. I don't think it makes sense as a legal matter for us to separate a vehicle operator from the vehicle for purpose of this analysis.
The vehicle was running, though, when the police officer got there?
That's correct, Your Honor.
And he had noticed that this person was either sleeping or unconscious, correct?
According to the record, not until he had approached the vehicle on foot. He had received a report that the person was either sleeping or unconscious via distance, but did not actually confirm that until he had already effected the seizure.
So it's not a safety issue to try to keep the car from rolling as he approaches? Because what if the person was startled and woke up from their sleep or their unconsciousness and accidentally, he doesn't know whether it's in park, whether it's in neutral. Isn't that all a safety measure?
I don't believe it's a reasonable concern in this instance, Your Honor, given that the officer received a report that the vehicle was parked in the marked parking space. Several minutes later, he arrives. The vehicle is still parked in the marked parking space. There's no indication that it is that the vehicle is in gear or that it poses any risk of rolling back at that point.
I know, but those are things a police officer doesn't know. So he takes the best measure for safety purposes.
Well, I'd also note, Your Honor, that in the officer's direct testimony on the record to the assistant state's attorney, he testified not just that it was to prevent the vehicle from being able to back up, from rolling back, but also to prevent it from being able to back up.
Why haven't you waived this claim until we get to the point where the windows roll down?
Because as I mentioned, we do believe that a seizure was affected as soon as the vehicle was blocked in.
I know, but you didn't argue. Why didn't you argue that below? Why did you skip to the next contact, which is when the window rolls down below with the trial court? Because the trial court never addressed this claim.
Your Honor, we did.
You say you argued in the alternative, but when you argue something in the alternative, I would think the trial court would be expected to address both claims in the alternative. In this case, the court tried to make it clear, what are you really claiming here? And from the court's perspective below, you were only claiming an illegal seizure from the time that he knocks on the window.
Your Honor, I don't believe that's correct based on the record.
All right, so based on the record, when did you advise the trial court, or when did you ask the trial court to articulate that you were also claiming the point where your client was still asleep and the police officer parked in back of his car?
I believe we explicitly stated to the court, Your Honor, that we believed that the seizure had been affected at the moment that the officer had parked behind the car.
Why didn't you ask the trial court to articulate, since the trial court doesn't seem to address that particular point in time?
I believe that the trial court, in fact, did, Your Honor. Forgive me for not having the immediate reference. I can search the record if it would help. But the trial court did make reference to the fact that she had difficulty finding that the defendant could have perceived being seized because he was asleep. She did address that point before moving on to the
because I think she was acknowledging that you weren't going to try to claim that. Trial court was acknowledging that you were not going to try to claim that point because it made no sense. She was clarifying, not making a finding. She was clarifying why you were only going to pursue the second alternative.
I don't believe that's a correct reading of the record, Your Honor.
All right.
And further, I believe that the record is sufficient for the court to consider that argument as it's being raised now in either case. So to continue on, if there are no...
Hang on, counsel, there are other questions. Justice Khan?
Thank you, Chief. I actually had the same question that one of the same questions Justice Keller was asking you about, which is what your argument was at trial. Your opponents say in their brief at page 6, and they cite to the record, trial on October 15th at page 68 and 72, that your client expressly abandoned the claim that he was seized at the moment the police officer blocked him, and expressly said you were only claiming that the police officer, that your client was seized when the police officer blocked him and he became aware of that blocking. And so your opponents are saying that your client expressly abandoned that claim. Are you saying they're wrong? And if so, how? Where in the record do you claim supports your view that you did not make that express abandonment of that claim?
So, Your Honor, that was a recognition of a fact on the record that the defendant was asleep. We did not at that point concede that that was relevant for purposes of the seizure analysis, nor do we concede that at this point. The argument in the principle was that the seizure was affected as soon as the officer had blocked in the vehicle. In the alternative, if the court were to find that that would not hold because the defendant was asleep, the argument in the alternative was that as soon as the defendant awoke, that condition still remained. He was blocked in. And in this instance, it would have also been late at night with a uniformed armed police officer knocking forcefully outside his window.
So, well, he was knocking forcefully because your client was
asleep, Your Honor.
Not responding, right? Let me ask you, so you're saying then that the state's brief erroneously is misrepresenting the record? Is that your position then?
I believe it's a creative reading of the transcript from the motions argument, Your Honor. But I don't believe it really reflects my intention. I certainly did not have an intention to waive that claim, which is why I'm continuing to press this.
But there's a difference between intention and statements actually made on the record and whether the trial court relied on those or not. So are you saying that to the extent the trial court read your statements to be that way, that it was not an intentional abandonment. Is that what you're arguing now? Because there's a difference.
I don't believe that we abandoned that argument, and I do believe that the trial court addressed it in her ruling from the bench in analyzing whether or not the fact that the defendant was asleep was a relevant consideration for her.
And let me ask you, counsel, one final question, because other colleagues may have questions for you as well, and I don't want to take up all the time. I noticed that there were no exhibits attached to the record. Was there ever any introduction of any pictures of the Cumberland Farms? You know, I'm looking at a gas station or Cumberland Farms. There typically aren't a whole lot of parking spaces and people are coming in and out. Mm-hmm. So it may be possible that you know, a police officer has to sort of park behind a car. Were there any photographs of the area of the Cumberland Farms and where the cars were? Was any of that introduced during the suppression hearing at all?
Not during the suppression hearing. In a subsequent hearing on a motion to dismiss, a video excerpt from the security footage at the Cumberland Farms was introduced. Unfortunately, none of the cruisers that were present at the scene captured dash camera video. The second responding officer, Officer Maria Matthews, took an iPhone video of the security footage starting from a point roughly 15 minutes after the encounter began, which does show the parking lot. There were ample spaces, and for what it's worth, by the end of this incident, multiple police cruisers had arrived and found places to park.
But there were no, I'm sorry, the video doesn't show who was parked there, if anyone was parked next to the defendant's vehicle when the officer first arrived. Is that correct?
The officer's arrival on the scene, Your Honor. It does show that there was ample parking available, both at the gas pumps and in front of the gas station. Additionally, this was at the intersection of Main Street and East Middle Turnpike in Manchester. There were plenty of available spaces, not just at the Cumberland Farms, but in adjacent properties.
But you still haven't answered my question. And my question is, the video starts 15 minutes after the encounter. So we don't know how many cars were there when the police first approached, correct?
That's correct.
There may have been spaces, but you don't know if they were full or not, correct?
We do know that there were spaces. We do not know if they were full. We do know that the officer intentionally parked as he did, however, based on his testimony. So I'm not sure how important a consideration that is in this particular case.
Okay. Thank you. Yes. I yield back to the chief.
Justice Keller, do you have another question? Counsel, you may continue.
Thank you. So as we were, as I initially stated, I don't believe any reasonable person in a situation where late at night a marked police cruiser operated by a uniformed and armed officer has positioned themselves to prevent them from leaving the area is going to feel free to leave. And that's as true for pedestrians as in the case of State v. Edmonds, as it is for drivers as in State v. Clark and State v. Januszewski. Second, the blocking of the vehicle to prevent it from being able to leave is a use or display of physical force that under both the state and federal constitutions is sufficient to create a seizure. By creating a physical reality that, yes, Your Honor.
But counsel, the officer's testimony was sort of dual. One was to prevent the car from backing out, but the other one was to prevent it from rolling back. That's a question of fact, isn't it?
Apologies, Your Honor. Which portion of that is a question of fact?
Whether the officer, well, it's a question of the officer's credibility for one thing, and it's also a question of fact as to why the officer parked the car the way he did. So, right? He said that one was to prevent basically, I think you would say prevent the car from leaving. But the other one was you have a situation where the officer is notified of a possible medical emergency. There's a person in the car who's sleeping or unconscious. The officer doesn't know whether this car could roll back or not roll back. I mean, I can see those facts in either way. That one, he intentionally blocked the car in just to block the car and prevent the person from leaving. Or I can look at this and say there was a medical emergency. The officer was doing utmost to protect himself and others around him. Why? And the fact finder seems to have taken a position on one of those. There's evidence in the record for both. What do I do with that?
Your Honor, I would note two things. First, this original call to the police department, according to Officer Loud's testimony, was on the non-emergency line. So had a person believed there was a medical emergency, I would presume dialing 911 would have been the more reasonable course of action.
The fact finder gets to weigh that evidence. The fact finder gets to say whether there was an emergency or not an emergency, what indicia of an emergency there were. The one thing we do know is that a person called in and said there's a person either asleep or unconscious, correct?
Yes, Your Honor, which brings me to the second point, which is whether the idea that the vehicle would have rolled back in that instance was reasonable for the responding officer to think, given that he had been called for a vehicle that was in a parking space and he arrived to find the vehicle in the parking space. I would assume that the idea that an object at rest remains at rest unless acted upon by an outside force.
Except if the person could be asleep with the foot on the gas or the foot on the brake, and I'm just trying to figure out why am I going to go into the set of facts that you want the court to go into when the fact finder doesn't necessarily agree with you.
Well, we believe that the fact finder had clear error in how she analyzed the situation
and so the standard would be clearly erroneous for the facts.
Yes, Your Honor.
Okay, continue.
Thank you. So we believe that the physical reality that a person cannot leave a scene is the most relevant consideration here. But also, there is a strong policy argument for, my apologies, Justice Mullins, did you have a question? I'm sorry, counsel. Justice Mullins?
Yes. You certainly could get back to this area, but I had a question about the adequacy of the record. And your client was convicted of interfering. Is that right?
Yes, Your Honor, 2 counts.
What is it that what are the statements or conduct you were trying to suppress? Because just looking at the rendition of the facts, and the state points out we don't have the transcript, but looking at the rendition of the facts, there was some conduct at the scene. It looks like there was investigation both at the scene and maybe a little after. There was a refusal to submit to the breathalyzer test. It's not clear what went into that, if he was sort of physically obstructing getting the breathalyzer test. So interfering could be a number of things along that path. And I don't see the statements that your client made that you would want to suppress. So maybe just sort of as a factual record matter, what is it that you were trying to suppress?
Sure. So at the scene, Officer Loud reported that the defendant had been asked for his name and replied either Greg or Craig. He wasn't sure which we had said. The defendant declined to provide his last name, his date of birth, had stated, "I don't know how I got here" at one point in response to a question for identification. And the officer's observations of the defendant after the seizure had been effected. We were attempting to suppress those as well. Our original motion was filed.
Is that what the state argued? But I guess I'm wondering if that's the basis of the conviction. Are those the facts that the state sought to prove were the interfering, or something else that happened during the rest of the investigation?
To be clear, the state also introduced evidence that the client resisted being handcuffed, which necessitated the calling of backup officers to the scene. However, the totality of the state's case included events that happened while the defendant was still seated in his vehicle. So we wanted.
How do we know it's not? How do we know it's not just the resisting that forms the basis of the conviction?
Frankly, Your Honor, we don't. We know what the state presented, and we know that the state's presentation would have been affected by the granting of the suppression motion. So had they presented a case based on a narrower string of facts, it's possible that the outcome would have been different.
So what about the reverse of that? I mean, the reverse of that is if you're successful and all you're challenging is the name, date of birth, the questioning for ID, and the observations made at the scene, even if you're successful on that, his conviction would stand if it was based on the resisting, right?
I do have a question as a matter of law as to whether or not a conviction for interfering can withstand the lack of an officer's testimony as to what exactly he considered to be interfering conduct. So had we suppressed the officer's observations about what had happened at the scene, it's likely that he would have been able to present a less comprehensive case.
No one testified about his resisting?
No, there was in fact testimony about that from both him and Officer Matthews regarding that arrest.
So if the jury disbelieved your motion to suppress didn't address the resisting. So if the jury disbelieved all of the testimony and said you were right, that it wasn't resisting to not give your name and date of birth, but it was to resist the putting on the handcuffs, wouldn't that be enough to sustain the conviction?
Your Honor, our motion addressed everything that happened between the moment we claimed the defendant was seized and the moment the defendant was Mirandized. So that would have encompassed the entirety of the case.
Okay.
Anything else, Justice Mullins?
No.
Justice Ecker? Justice Ecker, you're muted.
Sorry. Two questions. Does a person have a common law right to resist being handcuffed for an illegal arrest?
No, Your Honor. We've eliminated that here in the state of Connecticut. Any resistance here in the state of Connecticut, as far as I'm aware.
Well, I know there's a statutory elimination for physical. I don't know if it's physical resistance. You can't hit an officer. I just wonder if you can sort of, resist being handcuffed or not. But if the answer is no, then that's fine. My other question is just, I'm just wondering on your theory what the police officer was supposed to do. Let's say that instead of blocking, he had found there had been another parking space. There was a concerning situation late at night with a man, and the car was running, he could either be medically compromised or he could be drunk. I think those are both reasonable, or he could just be sleeping, I suppose. But there could be a problem. So what's he supposed to do? He's supposed to knock on the window, and then let's say that your guy awoke and just gave him a thumbs up. Everything's fine. I'm not rolling down the window. Thumbs up. Is the officer at that point? Is the officer required to walk away?
I believe so, Your Honor. That would have the hallmarks of a consensual encounter between.
There's not a reasonable and articulable suspicion at that point, at least to establish some kind of a contact with the person to make sure that they're not drunk.
A consensual contact would be permissible at that point, Your Honor, but not a seizure, and I don't believe that there's enough for a Terry stop at that point. A person asleep at 2 a.m. is simply not suspicious enough to give rise to grounds under Terry v. Ohio.
So the key thing is that when the fellow rolled down his window, and we don't know if that was done at a time when he was aware there was a police cruiser in his rearview mirror, right?
We don't know his awareness. The defendant did not testify.
Okay. Thank you.
Thank you, Your Honor.
Justice Keller?
What time of day was this, counsel?
This was around 2 a.m. The initial call.
All right. So it's 2 a.m. and someone's noted to be asleep or unconscious in a car and the engine is running. Doesn't that give you a reasonable suspicion that this could be drunkenness? Because if you were just going to sleep and you parked, or there was a medical issue and you had managed to park, wouldn't you have turned off your engine? I mean, the fact that he never turned off the engine, doesn't that suggest a reasonable and articulable suspicion there may be some drunk driving occurring? Because we often see cases where drunk drivers found on the road and it's still operating. He's still in the car is still running. Because they're too drunk to know enough to turn it off.
Your Honor, I don't believe that holds. This was an issue that was examined by the Vermont Supreme Court in State v. Justice in 2004. And the court there reckoned that the problem with that analysis would be what happens during cold months when somebody pulls off for a nap. Do their constitutional liberties change depending on the season? And they specifically—
What season was it in this case?
It was
winter?
Your Honor. It was October
What?
5th. It was October.
October 5th. Okay.
So
All right.
and in the middle of the night.
All right. Thank you.
Thank you, Your Honor.
Sorry. Your time in your main argument is up unless you want to use some of your rebuttal time.
No, thank you. I'll reserve that time for rebuttal.
Thank you, counsel. Attorney Segru. Attorney Segru, you're muted. Attorney Segru, you're muted.
He's saying he needs Justice Doria to unmute him. He can't unmute himself. Is that, that's what if I'm reading lips correctly.
I don't know. I think he's going to sign back in.
I hope he's going to sign back in. I hope I didn't just knock him out.
He's coming back now.
But he's.
Once he speaks, we can see him. Is he still muted?
Your Honor, I can see him and he is muted.
He's muted
Okay.
on mine.
Okay, I got to figure out how to.
No, he's still muted.
Yeah, that might be.
Can you hear me now?
Yes.
Okay, I got it.
I can't see you.
terrific.
Can you turn your video on?
That was entirely unintentional, Attorney Segru.
Oh, that's okay. Hang on. My camera is on.
There you go.
Okay.
Thank
All
you,
right.
Attorney Segru.
Oh,
I
no problem.
apologize on behalf of Justice Doria.
No, I won't hold it against them. Morning, Your Honors. May it please the Court, Timothy Segru, Assistant State's Attorney. I represent the state in this matter. Let's talk first, if you will, about the abandonment issue. As I read the record, and it's obviously up to this court to decide, the defendant abandoned the seized by blocking when he was asleep or unconscious and substituted the blocking plus awareness. If you look at the defendant's appendix at page A104, you'll find the place in the record where the state relies on, which is after the state had argued to the trial court he was asleep or unconscious. Obviously, there could be no detention there because he wasn't aware, and the defendant agreed that he would not have known that he was blocked in. And then he cited to the reasonable person, quote, awakened by a forceful knocking with a police car blocking him late at night. And then another quote, he was effectively constitutionally seized at the moment that the police officer blocked him in, and he became aware of the fact that he was blocked. And I think a reasonable view of the trial court's decision is that's actually how Judge Prats resolved it. And she offered kind of a parenthetical musing about the unconscious asleep part and seemed to dismiss that, but she didn't make a ruling on it. In fact, she went and relied upon the community caretaking function. And I think one of the interesting things about this case that Your Honors might want to ponder is, as I read the community caretaking function, that's a justifiable excuse for a constitutional event. If you don't have a constitutional event, you don't need the community caretaking doctrine. In fact, you don't need anything. If there's no constitutional event, it's an exception to the warrant requirement. It's a reasonable warrantless intrusion. And that's where I think there's some ambiguity in the trial court's ruling. And that's why if you look at the state's brief, I think it's on page 10, I did it both ways. I did it as there was no seizure up to the point at which it became a drug driving Terry stop, and that it was a seizure. You can assume it was a seizure from the moment the police car pulled in. It would be excusable and justifiable as a community caretaking function. So I think that's where some of the confusion in this case arises, and Your Honors might want to think about that. I think Justice Keller is absolutely correct about the car. It's a running motor vehicle. There is, in fact, the police know now, a complaint by a clerk who was concerned enough to call the police, and it was a more or less a medical complaint, not a drunk driving or behavioral complaint. And you have no idea if the car is in gear or if, in fact, it's going to lurch backwards should the operator be startled by the officer banging on the window. And the testimony from Officer Loud and the court's finding was that this was done as a matter of safety and security, not as a matter of the police interfering with the defendant's rights. So I look at it as he was seeking to have the car, prevent the car from either rolling backwards or backing up, not backing out and leaving. Never said that. It was backing up, moving backwards, in which case it would have arguably posed a danger to anybody behind the car if the police car wasn't there to stop it. And it's entirely reasonable under those circumstances, I think, for any of us in that situation to appreciate the concern expressed by Officer Loud about parking behind the car so that until he could ascertain what was going on, so the car didn't move, not so that the defendant couldn't leave. There was no indication at that point that it was drunk driving. And in fact, the citizen complaint, again, was really a kind of medical and not, it could have been a drunk drive, of course, but it wasn't at that point. And I think, you know, I will say something. The letters of yes, Justice Ecker, I see you have your hand up.
Thank you. If I may, Chief.
Yes, of course.
So just to clarify in my mind, I guess I had it backward, but you do agree that the issue in front of us is whether there was a seizure at the time that he awoke, at least at the time he awoke and realized he was being blocked in.
Yeah, I agree, Your Honor. I think that's how the trial court looked at it. But again, it's not entirely clear because, some of the cases do. Foote does the same thing. The appellate court's decision in Foote, it's a little bit careless with the seizure language. And it seems to hear that Judge Pratt found that the seizure happened after smelling the alcohol in his breath, where the defendant was arguing, I think the seizure happened when he came up and knocked on the window and the defendant became aware, and that's where it clicked off.
Right, and I guess what I'm wondering is in that little gap of time, I agree with you. As I saw Judge Pratt's, she goes right to the smelling the alcohol.
Right.
But there's presumably a gap of time, however short. And this is assuming that he realized not only there was an officer at his window, but there was a squad car behind him. If there is a period of time, even seconds, between the time when he realizes that and the time when he rolls down his window, is there any significance to that time period? I guess a different way to put it would be, could he have lawfully refused to roll down his window at that point and just said, catch you later?
Yeah, that certainly is a different case in terms of, I'm not sure. In this case, it doesn't matter because I think the community caretaking function encompasses everything Officer Loud did from the minute he drove into that parking lot up until the point that he smelled alcohol. And then it clearly became a motor vehicle Terry stop to do a drunk driving investigation. So there may be a case where that gap is constitutionally significant, but I don't think it's this case.
And if I can just ask you a question then about that, I haven't read all the cases on community caretaking function. I've read a couple of them, but I don't claim to be an expert. It's a fuzzy doctrine in the sense that one person's community caretaking can be another person's law enforcement initiative, because sometimes people in need of care also pose a risk, a threat to the public, not only to themselves. So how do we? Is that a purely subjective test? Is it based upon what the police officer's stated purpose was? How do we assess when an event is a caretaking event versus a criminal investigative event?
I think it's not subjective, Your Honor, as far as I read the cases. I think it's a reasonableness test. It's an objective test under which the police officer must have a reasonable basis that there is, for lack of a better term, some potential for a medical or health crisis, and that is why he or she is there, and that is why he or she is acting. Certainly, there could be, police officers could harbor other things in their mind. I don't think that that's necessarily relevant here. Again, I think it's a reasonable belief test, and that's what you have here. And this case, I think a really important part of it is the police are acting in response to a citizen's complaint. They're not acting proactively. It might be a very different case if Officer Loud said, it's 2 o'clock in the morning. I've been a policeman in this town for a long time, and I know that people like to drive over to the Cumberland Farms there after they've had a few pops and sleep it off in the parking lot. So I'm going to go see if I can find some drunk drivers. That would be an entirely different situation, which we don't have here, where the police are reacting to a citizen complaint, again, that from this record suggests was entirely medical in terms of the defendant's condition and his wellness, not his state of sobriety. So I think you make good points, Your Honor, that this probably just isn't the case for it. I do think it's an interesting question, even if there's some, not confusion, but maybe ambiguity with respect to what's going on. And the question you asked about knocking on the window as to whether the defendant could just give a thumbs up or just wave and essentially dismiss the police officer. That's an interesting question, because I think the police do have an obligation to the other people on the road, even in a non-drunk driving context, to make sure that this person is okay to operate a car. And that might require some contact more than simply a thumbs up. It may require the window to come down, the door to open, so we can say, okay, this guy actually is okay. I don't have to worry about him driving out, crossing a lane, not because of sobriety, but because he's medically not well. But again, I think that's a different case than we have here in this case.
Mr. Segura, there's a question from Justice Doria.
Yes, Justice Doria.
Thank you. And so then what is the what's the limit then on community caretaking? If let's sort of in the usual Terry parlance of confirm and dispel, let's say he got there and he and the tip or the call turns out to either have been wrong or maybe the condition has changed. So the car's not running, the guy's in the other seat, he's lying down, but he parked, legitimately in your view, he parked behind him. Does he have to move his car now or to investigate further, or if he did go further to rap on the window to sort of decide whether conditions had changed, it's okay for the car still to be behind him?
I think it would depend on the facts. And in a case like this, in a community caretaking function case, which the emergency doctrine is a part of, first question is it reasonable to believe that this emergency, this potential medical crisis is in fact happening? And two, do the police officers act diligently to, and I think the Terry language of confirming or dispelling what it is they're confronted with. They can't dawdle, they can't go off on a criminal context just for the heck of it. They can certainly make observations, they can absorb information that may point to a criminal direction, as this case ultimately did. So again, I think is it reasonably viewable as a medical emergency, and was the police officer doing anything that wasn't related to looking at the potential medical emergency that he was confronted with?
So there's nothing, I haven't read up on this a lot either, but it seems to me that this is nothing more than asking the usual question of, did the officer have a right to be there? Plain view, we ask that. Any other exigency, you thought there was a child in the hotel room and you came storming in. Well, maybe you thought you'd also look around while you were there, but did you have a right to go in there? Is there any more to the doctrine than just that?
No, initially I think that's a fair way to look at it. And again, in this case, whether it was a seizure from the minute he parked that police car, or it was a seizure closer in time to when he's at the side of the car banging on the window or interacting with the defendant, it doesn't matter in this case, because the using the car was integrally related to the community caretaking effort of preventing what could be a very dangerous large object from moving. Not to keep the defendant from getting away, not to handcuff him and make him stay there while the police conducted a surreptitious criminal investigation, but it relates to protecting people. And that's why this officer was there, to protect the defendant first and foremost, to protect himself and other officers who might get there, and anybody else who was using the Cumberland Farms that might have been walking behind the car when he knocked on the window and the startled defendant slammed the gas pedal and the car flew backwards. So I think it's, a pretty straightforward application of a warrant exception, much like the emergency doctrine, the exigent circumstances doctrine, Terry stop itself even, which ultimately this became for sure.
Thanks.
You're welcome. If I could just comment, I got 2 letters of supplemental authority, Your Honor.
Before you go, there's questions from Justice Ecker and Justice Keller.
Okay.
Not me. I just failed to lower my hand.
Thank you, Justice Keller.
I want to talk to you about your harmlessness argument.
Yes, Your Honor.
The new crime exception. Should we really consider that in light of the fact that you didn't claim it as an alternative ground? And,
well, yeah, I don't think you have to consider it, to be honest with you, because as I thought about it in a little more detail, the same problem that he has with no trial transcripts probably afflicts my argument with respect to the new crime exception. So I would rather rely on the argument that I make that even if he's demonstrated a Fourth Amendment violation, he hasn't proven that any tainted evidence was used against him in proof of the 2 counts of conviction. So, yes, Your Honor, I think you're probably correct about the new crime exception. I probably did myself in for the same reasons that I'm claiming the defendant did himself in with the adequacy of the record.
But you agree with Justice Mullins that there might be a problem here in determining whether any tainted evidence convicted him, correct?
Absolutely. We don't have the trial transcripts, and that's really a significant problem with respect to Officer Matthews, who is the alleged subject of one of the charges. The suppression record is essentially silent with respect to her. I don't even know what the basis of liability was for interfering with her or what evidence was adduced in support of that at the trial. That one's a real problem, and I think the same problems afflict that with respect to Officer Loud. The information is non-specific. We have no idea what the bases of liability were, what the arguments were, what the instructions were with respect to any of the evidence in the case. So I don't know how, again, the defendant's burden, and he says it's the state's burden to produce the trial transcripts. That may be true with respect to my new crime exception. I'll give him that, but not with respect to his Fourth Amendment violation claim. It's not enough just to show a Fourth Amendment violation in a factual vacuum. You've got to show that the Fourth Amendment was violated and that you were harmed thereby because evidence that should have been suppressed came in against you at trial. We don't have the trial transcripts, and I think that that's a fatal flaw with respect to it. And there's not a Fourth Amendment violation in the first place. That's the state's main argument. But even if there was, I don't think you can afford the defendant any relief in this case.
I have one last quick question. Did the officer testify that he smelled alcohol as soon as the window was lowered? Yes,
I think it was essentially contemporaneous. I think the trial court used the word immediate. I'm not so sure that the officer used that exact word, but yes, it was a effectively contemporaneous event of I'm okay and the police officer smells alcohol, as I understand the record.
Thank you, sir.
Justice Khan, you had your hand up and then back down again. Do you have a question?
No, thank you, Chief. I don't, because Attorney Segru asked answered what I would have had as a follow-up question. Thank you.
Okay, thank you. Justice Mullins.
Just on that last point, Attorney Segru, I think your claim is there was no constitutional violation, so we can just affirm what the trial court did. But I'm curious about the record in the sense that if the record's inadequate, which one comes first, I guess I'm wondering about. If the record's inadequate and we don't know if any of this information affected the conviction, why isn't that the primary argument as opposed to whether or not the trial court acted appropriately?
Well, because I think you need I suppose you could presume a constitutional violation and say the record's inadequate to afford relief and deal with it that way. You could certainly do that. I viewed it as you first make the determination whether there's been a constitutional violation, and if that's the case, the next question is, what happened as a result of that vis-a-vis the counts of conviction. That's kind of the way I did it, but I mean, I suppose you could assume a constitutional violation. I typically don't like to go that way, assuming a constitutional violation on facts, because it may lead to some confusion, and I don't think it's clear enough to do it that way, but it's obviously would be the court's call.
Thanks.
Thank you.
If I just have a couple of minutes. Oh, go ahead, Your Honor.
Mrs. Keller, do you have another question? Your hand is still up. You may continue, Mr. Segura.
Okay. The one other point I wanted to broach with the court was, I got 2 letters of supplemental authority very late in the game here that increased the citations in the defendant's brief by 50%. I've used supplemental letters of authority myself, and I certainly brook no quarrel with using them, but these 2 seem to kind of violate the spirit of the rule because they cite non-binding years-old out-of-state cases, all of which were available at the time of briefing. They came very late in the game, and in my view, all of them are inapposite. Most of them involve motor vehicle Terry stop cases, which hopefully I've convinced the court this is not one of those cases, at least not initially where we're quibbling. The only case that really does apply is the Justice case from Vermont that co-counsel mentioned, and I would ask the court to take a look at that case. It supports the state's position. And Justice says a seizure does not require suspicion of criminal conduct where the police are acting under the community caretaking function. And the only difference in Justice in this case is the belief in Justice that there was some kind of a medical issue wasn't reasonable, where the belief in this case plainly was reasonable based on the record. So that's all I have to say. If you have other questions, I'm happy to answer them. If not, I'd respectfully ask that the judgment be affirmed.
Thank you, Mr. Segura.
Thank you, Your Honors.
Attorney Lentini, you have your 5. Thank you.
Thank you. I believe I had reserved 7, but thank you, Your Honor. Just very briefly, Justice Ecker had mentioned the case law on community caretaking. The 2 major precedents that seem to be most at issue here would be State v. Foote and State v. Grazia, neither of which involved cases where the physical ability of the defendant to leave the scene had been implicated at the time that a community caretaking function was taking place. In Foote, which the appellee relied on heavily, the vehicle had outward signs of distress, the hazard lights were on, and the arresting officer had witnessed its inability to actually move, and was parked on a roadside instead of a parking space. The seizure was found to have taken place only when the officer had requested backup after observing erratic behavior on the part of vehicle occupants, giving him a reasonable and articulable suspicion. In State v. Grazia, the case that the trial judge relied most heavily on, that involved a car that was disabled in a roadway, or rather that was parked in a roadway, originally in gear, with a non-responsive driver. Again, you don't have the same liberty restriction of an officer blocking the vehicle in, and the initial contact with the driver in that case provided a reasonable and articulable suspicion for further investigation. That's not the case here. Where the seizure took place, in this case, no reasonable and articulable suspicion existed, and the community caretaking function could have been achieved without that seizure being a component of it. In terms of the question of the sufficiency of the record, which has clearly occupied both the court's mind and counsel's, I would note that this court, if it really does feel it necessary to supplement, does have the procedural supervisory authority under practice book section 60-1 through 60-3 to get anything from the lower court's record. With our apologies for the inconvenience, but I would rather the merits of this case not be overlooked based on the procedural question at issue here. The state argued that the community caretaking function authorized the officer to prevent the vehicle from being able to back up. He distinguished between backing up and backing out. I'm not sure I understand what that distinction is. Anytime a vehicle is operating in reverse, there is an ordinary amount of risk that happens. Preventing an ordinary action, though, is the quintessential nature of a seizure, because it's preventing the liberty to perform an ordinary action. Preventing a large object like
counsel, I want to plumb that depth some.
Thank you.
You have this community caretaking function, and I'm still trying to figure out how you're distinguishing that situation from a situation that's a seizure. Can you help me with that?
Sure. The community caretaking function allows what would essentially be a consensual encounter between law enforcement and civilians. In this instance, the hallmarks of a consensual encounter were absent because of the officer's decision to block in the vehicle.
But hang on. And that's where I'm having the problem, and I really am. It maybe I'm just missing it entirely. But if there's a situation where a person is in a dangerous machine, and cars are inherently dangerous machines. I mean, they're over a ton. They can accelerate very quickly, whether you want them to or not. The officer is on notice that there's something going on where the individual is either asleep or medically compromised. And he comes there and he thinks, hey, this is a car. This isn't a person sitting on the sidewalk. I have to basically make sure that this thing doesn't hurt anybody else or hurt me. I'm having a problem seeing this being a seizure. Or it seems to me your brother counsel is basically saying that if you're operating under the medical caretaking exception, then there's no constitutional event. Help me with that.
So the responding officer had a reason to believe that a person was asleep in the middle of the night. He had reason to believe that the car was parked in a parking space before he arrived, and when he arrived, the car was still in a parking space. He could have ascertained whether or not there was a medical emergency, whether or not the car was in gear. These are facts that could have been gleaned through a consensual encounter, and had he decided at that point that the restriction of the car's mobility was necessary for public safety, then he would have been free to seize the vehicle. But that did not happen here. The seizure took place before there was any reasonable belief that there was a medical emergency taking place. All he knew at that point was someone might be asleep and a call had come in on the non-emergency line. If there were a 911 call that a person was having a seizure in a car or was showing outward signs of medical distress, that might be a different situation. Or if there was an
but didn't the caller say he could be asleep or unconscious? I mean, that's the information that we have.
Right.
And I'm trying to figure out this whole thing where it seems to me you're saying that the person making the 911 call has to do this divulge information that may be further than the knowledge of a layperson would know. I mean, just, somebody's in a car, you know they're not moving. That's what he reported. I'm having a problem because he didn't do this on 911 versus just regular call into the station. That doesn't cut it, I don't think.
Well, that's a relevant standard when it comes to things such as anonymous reports of erratic driving, for example, under Navarrete v. California. Just the idea that there is more reliability inherent in a 911 call, and that is the line that people are accustomed to using for true emergency situations. In this instance, the caller took the time to find a non-emergency line and call it in. That's not something that people have immediate knowledge of. If there is a true emergency, you're not usually going to go to the phone book before dialing the emergency line. But that being said, what the caller reported would have been no different had he been simply taking a nap or had he been having a heart attack. The officer's job was to ascertain which it was before effecting a seizure.
Justice Khan.
Thank you, Chief. So to follow up on that, counsel, your argument was that your client was effectively constitutionally seized at the moment that the police officer blocked him in, and he, your client, became aware of the fact that he was blocked. And you argued that it was when the officer knocked heavily on the window. How was the officer supposed to conduct a check of the information the officer received without seizing your client? By your definition, how was he supposed to do that? Was he supposed to hover over the car? How was he to accomplish that?
By parking literally anywhere else, Your Honor.
All right, but your argument was that the seizure occurred at the moment the officer approached the window and knocked hard, and your client awoke and became aware of the officer's presence. How was the officer supposed to avoid a seizure if you say that's a seizure? How was he supposed to conduct the wellness check without doing that?
Your Honor, the factor of the car being parked behind the defendant's car is still relevant in that instance under the reason.
I understand that, but you argued the alternative. And my question to you is, how would the officer have conducted a check without seizing your client by your definition?
Your Honor, my argument in the alternative didn't ignore the presence of the car being parked behind him. That is still a component in the analysis. So if we were to go through the factors of a reasonable person standard, a reasonable person can still consider that the car is blocked.
So if we disagreed with you, you also lose your alternative argument. Is that your position then? If we disagree with you, then it's not a seizure. The fact the police officer walked to the window and knocked on it?
Not necessarily, Your Honor, because the fact that the vehicle is still impeded from leaving is a relevant consideration in the analysis of whether or not a reasonable person would have felt free to leave. Again,
so are you saying then your argument is no longer in the alternative? You're going back to that it's just the driving up and blocking the car?
Your Honor, I believe that the two arguments we have presented are that driving up and blocking the car constituted a per se seizure of that vehicle as it was impeded from being able to leave the scene. Alternatively, blocking in the car and approaching it as a uniformed and armed police officer who's projecting some degree of force is also sufficient to create a seizure. We are not saying that the presence of the car becomes immaterial in that second argument. And I don't believe that the court would be saying that either.
Thank you.
Thank you, Your Honor.
Justice Daria, did you show a sign that time's up? Thank you. Counsel, you may give a grace note.
Thank you, Your Honor. Just in conclusion, where we believe the trial court erred was in treating the question of a seizure as a subjective one based on the officer's intent rather than an objective one based on the officer's conduct. The perspective that matters isn't the officer's, but a reasonable person in the position of the defendant. For this reason, the court should reverse the trial court's ruling as press. And thank you very much.
Thank you, counsel. And I have to give credit where credit due. That's Judge Flynn saying that I borrowed. From my old days at the appellate court. I want to thank counsel for coming in and doing this argument virtually. You're helping us to fulfill our constitutional obligations as well as helping your clients have their cases processed as quickly as we possibly can under these challenging circumstances. Thank you both for your professionalism. With that, we are adjourned for the day. I will see my fellow justices in the virtual conference room. Thank you very much.
Thank you, Your Honor.
Thanks.